Welcome to PoliPulse, your daily South African political pulse. Today, the Madlanga Commission is back in the spotlight, and there are fresh revelations about state capture that you need to hear. Stick with me for the breakdown. Here's what's happening. Click, like, and subscribe. Roll the clips.
Court to assist Advocate Latshwayo. On arriving at her office, we found that the investigating director had not yet arrived, and we left a message with her personal assistant, Ms. Innocent Sikhukhune. On my way back to my office, Ms. Sikhukhune telephoned me to say that she had discussed our request with the investigating director telephonically, and that the investigating director had agreed that we could attend court as requested.
Did you ask or did you find out who and how Ms. Latshwayo came to be allocated? Who selected her?
Yes, I only came to know afterwards. Commissioners, I asked and I was told, and the information I got was that she was appointed by the ID, and I was told that initially the only prosecutor in the matter was Advocate Ramseni, Drew Ramseni, and that Latshwayo was then also allocated, or at least designated to the matter around May, so earlier, just shortly before the arrest. In this case. In paragraph 26, when we arrived, we were then given permission by the ID to go and assist in court. When we arrived at court, we found Advocate Latshwayo in the company of the investigating officer, Mr. Padayashe, and evidently overwhelmed. The court was about to commence, and the J15, which is the administrative form to which the charge sheet is attached, had not been completed, there being some 7 accused involved in the matter. Advocate Vedboy obtained the necessary J15. I remember she literally rushed to the clerk of the court, brought a blank form. I then took the docket from Mr. Padayashe. I then started reading out the names of the accused as they appeared in the docket. To Ms. Vedboy, who was then, to Advocate Vedboy, who was then completing the J15, which was then handed to the clerk to register the matter on the book. Our assistants enabled Advocate Latshwayo to consult with the defense legal representatives. The courtroom was full of police officers, family members of the accused, and members of the press. Advocate Vedboy and Shikovi obtained seats at the back of the court. As there was nowhere else to sit, I then sat in front next to Advocate Latshwayo, and Mr. Padayashe, the investigating officer, was seated directly behind us. I was not the prosecutor in the matter. My colleagues and I attended solely to support Advocate Latshwayo. The proceedings commenced before the magistrate, Mr. Madlanga, whom I did not know and was seeing for the first time. Advocate Latshwayo conducted the bail proceedings on behalf of the state, indicating that the state was not opposing bail and setting out the reasons. The legal representatives of the accused moved their bail applications by reading their client's supporting affidavit into the record. At various points, Advocate Latshwayo experienced difficulty in answering questions from the court and conferred with me and with Mr. Padayashe, who was seated behind us. In the course of dealing with the bail application, Advocate Latshwayo asked the court to impose a condition that the witnesses not be contacted or interviewed by the accused. The magistrate indicated that he required a list of the witnesses, as he could not simply warn them, and he appeared not to be satisfied with her response. The magistrate then invited me to address him, observing that I appeared to be from the same office. And maybe just to add here, Commissioners, I remember he precisely said, because they were engaging with Advocate Latshwayo, and he then looked at me and he said, okay, let the gentleman seated next to you address me. He appears to be from your same office, because now and then Latshwayo kept on talking to me and at the same time with Mr. Padayashe, and that is why the magistrate said, let this gentleman address me. Before doing so, I then asked Padayashe whether a bail statement or affidavit had been prepared.
What is a bail statement? What would you find in there?
Commissioners, this matter, as I understood at the time, fell under Schedule 5 of the Criminal Procedure Act. And Schedule 5 and Schedule 6, these are serious matters. Schedule 5, the accused to be released on bail has to bring an application and satisfy the court that it is in the interest of justice that he be released on bail. What we do as the state, to avoid the investigating officer to testify viva voce in court, he then compiles an affidavit setting out even if the state is not opposing, the reasons why we are not opposing. For example, we would have verified the addresses of the accused. The statement will state, we've checked their criminal records. They don't have criminal records. They are not a flight risk. They are gainfully employed, and all those kind of issues, they will come into the statement. We either do that by way of an affidavit of the statement, or the IO has to go into the box, and as the prosecutor will then have to lead him to cover all those aspects.
And you say that's something that happens as a matter of course with Schedule 5?
It has to happen. I know, Commissioner, that there are instances where the state is not opposing, even when the state is not opposing bail, and the prosecutor addresses the court from the bar saying, we're not opposing bail. I know of instances where the courts would have insisted at least on some form of evidence, formal evidence from the state, at least by way of an affidavit from the IO or so. And I do not have case law with me, but I know there's a case or two where the court would have also said, even when the state is not opposing bail, but the court is sitting, the court needs to be assisted by the two parties. And even when the state is not opposing bail, but you, as an officer of the court, you have to address the court, say why you are not, give this information to the court. So if you have compiled an affidavit, it's easier for the court. You read it into the records saying these are our reasons. Then when the court evaluates whether or not the accused has met the onus of proving that it's in the interest of justice that he be released on bail, the court has the benefit of both the state and the applicant's evidence. But in this case, the bail application or the statement was not done, which was one of the things that made me realize that this team did not appear to have been ready for this bail application. I would have expected them to, because when we were in court, I then asked Brian, just before addressing the magistrate, I asked him, did you compile an affidavit? Because now I could see the magistrate was going to engage me. So I wanted to speak out of an affidavit, not just give the court information which I was not privy of. But I remember asking him about the issue of the list, and then quickly he said, no, we have other outstanding investigations against some of these people. So that is why we don't want the list of these people to be known, because if we list them, that's going to impact on our outstanding cases. And that is what I then delivered to the court when the court was asking Tlatswayo, why not the list? I'm at the paragraph where the magistrate invites me to address him, and before doing so, I then asked Padayashi whether a bail statement or affidavit had been prepared. It had not. Mr. Padayashi explained that the witnesses had been told that if they were contacted by the accused, they should immediately report to him. And the existence of that other investigation. This is what I delivered to the court. On that...
Sorry. So where you say in line 1, 2, 3, 4, 5, there's a sentence that starts, so that there was no danger in that regard. it's preceded by where Parachi explains to you that witnesses have been told that if they are contacted by accused, they should immediately report it to him. And then you say, so that there was no danger in that regard. Can you just explain what you're addressing there?
Yeah.
Where you say, so.
And that's your PoliPulse brief for today. If this helped you make sense of the madness, smash that like button, subscribe, and hit the bell so you never miss a breakdown. For more South African stories from a youth perspective, check out our sister channel at Mzansi Pulse. I'll see you tomorrow. Stay sharp, South Africa.